aim of the it's fine. The aim of the presentation is to cover the basic concepts and the main legal definitions. So when you read an agreement, you are able to understand what they actually mean and navigate all the IP situations better and maybe flag some moments when you have to be a bit more careful. So, may I go further? No. Okay. Okay. So this is the plan. First, I will cover the basic concept so you do understand how IP works, and it will be helpful further to understand also like the agreements generally. And then I will go try to explain licensing agreements and difference between licensing and transferring, and then also uh, IP guarantees and trade chapter intellectual property type, and then conclusions. Okay. Okay, so let's start with the very beginnings. Uh, and so first thing I want to say about intellectual property is that when we talk about it, we mostly mean intellectual property rights. And rights are non-tangible, they are purely legal concept, and they exist because our legal system recognizes intellectual property rights. Otherwise, um, they are like, it's just a legal concept. But um, this is like it is important to differentiate among objects and rights. And we talk, and this presentation is mainly about IP rights. So, what is intellectual property? Here I have listed the groups of the types of intellectual property. We have copyright, we have industrial property, and of course, as always, there is other, something a bit more peculiar. Um, Copyrights are works of authors. So in the center, we have a natural person who has created something using their artistic freedom. And copyright in Latvia is regulated under copyright law. Then we have industrial property. And when you read laws regarding industrial property, like trademarks, patents, and designs, you can feel that this is a bit different. This is more about commercial aspects of those objects, while copyright, when you read the law, you feel it's a bit more about the author. But the main difference between copyright and industrial property is that copyright is protected since the very moment the work has been created. You don't need to register it. Other contrary to industrial property, for example, trademarks, patents, designs, these are things usually subject to registration. So if you want to have a protected patent, you have to register it with the patent office. And then we have trade secrets. We will cover those a bit later. We have this thing in our commercial law that we provide protection to company names. So you don't have to have a registered trademark, but you can have you already have some rights to protect your firm's name, like SIA Abolits, for example. You can already prohibit someone using it. And as for startuppers, I think it's most importantly to understand that computer programs go under literary works and they are protected under copyright. But of course, they have their special provisions, like they are not regulated equally as, I don't know, novels of Rudolf Blauman. But technically, it's the same category. So this is the very first thing I said, that we have IP rights and IP objects, and they can exist, if I may say, like separately. So you can own the object physically, but you cannot own, and in the meantime, you can also not own the rights. And you can, for example, um, own the rights, but not the physical object. I don't know if that makes sense, but um, as an example, I can use like a book. When you go to a bookstore, you buy a tangible object, but it does not give you IP rights to start producing more copies and selling them. So objects and IP rights are separate things. And when it goes to the contracts, the contracts are about IP rights, like the rights to produce tangible things out of IP um, and use them for commercial transactions. So then these IP rights are divided in two groups. And this is also important for uh, agreements because agreements mostly are about economic IP rights. So moral rights are the ones that are they exist to protect the author's personality, author's or creators' creative freedom, reputation, and things like that. And they cannot be transferred, they cannot be waived, and they are not subject to economic transactions. But you have to be aware that they exist because sometimes they can be burdensome when you want to do something with the IP you have bought from the third person, for example. The most, so to say, problematic moral rights are the right to revocation and right to prohibit making changes in a work. So there is an exception in copyright law regarding computer programs. For computer programs, authors cannot use these moral rights, but for other types of authors' work, they can. And it can, for example, in architectural designs, the projects go for a very long time, and maybe after 10 years you need to make changes, and then the moral rights become very important. And in terms of contract, if you want to, in IP contracts, if you want to do something more, the moral rights, and you want to address the issue, you have to do it expressly. Because if you use the sentence that states all IP rights existing and created in the future are transferred or licensed, this sentence will cover only economic rights. Because, yeah, moral rights cannot be transferred, licensed, therefore, no one would interpret it as covering moral rights. You have to address them. So then also IP rights are territorial and limited in time. They don't um, they don't exist forever. About territoriality, it's basically when you plan your IP rights, you have to think of this territoriality and your business operations in which markets you want to operate and provide your products, because we don't have a thing like a worldwide IP right. Even if you can have a patent that are protected in almost all the countries, it's still subject to all those jurisdictions. It's not like a one jurisdiction. And and at the end, if you have like a problem, you need to, I don't know, litigate for something, then you have to deal with those jurisdictions where the issue happens. Um, for example, a trademark. If you register a trademark or a patent in Latvia, it's protected only in Latvia. And if you want it to be protected in other country, you have to register it there. So technically, if you haven't registered in a third country, it's not protected there. Um, in EU, we have EU trademark where you can register a trademark in all EU member states with one application. But at the end, even if it feels like it's like the jurisdiction is EU, at the end it's still 27 jurisdictions. So it's like pieces of a puzzle. And limitation in time. This is important aspect when you plan your operations and product launches and maybe like in the further future. Because IP rights are not protected forever. For patents, it's 20 years after registration, and after 20 years, like everyone can use the patented invention. This is the thing that happens in pharmacy. For example, when the pharma patent expires, then other companies can also produce the drug, not using trademark, but naming it differently, but it's the same invention. So that was the introductory part where I covered the basic concepts. And now let's move on to agreements. So here I want to talk about licensing and transferring and the difference among those things, because uh, it is very important to understand the consequences of those agreements and to understand if this is the concept of transaction that works for your aim. So licensing, it's all about giving the right to use IP rights. Transferring is like giving away the ownership. And as an example, okay, I will check my time. Okay, I'm good. So as an example, I will use a house or apartment. So you can be a tenant and you can rent an apartment. Namely, you have a right to live in it, but you don't actually own the apartment. In terms of IP, it would be licensing. You can actually also buy an apartment and become an owner. And then in terms of IP, it would be transferring. You give away ownership or buy it. So that's the difference among those two agreements. Then on the left side, I have picked like some nuances from copyright law. Maybe that could be useful to know when you read your own license agreements. So in Latvia, under our copyright law, our perpetual licenses, namely the ones that are not limited in time, they are revocable. So if you want, that can be good for you, but if you want to have a very strong license agreement, so most likely you will have to set a specific term. Then exclusive and non-exclusive licenses, I think it's self-explanatory, but exclusive licenses is one licensee and non-exclusive are many licensees. And also, it is important to keep in mind that in license terms are interpreted narrowly. So if there is something important to you, then you have to make sure that it is like expressly and clearly stated in the agreement, because when you go to the court most likely won't find things that are not in the agreement. They won't interpret like very widely. Um, for example, the territory. If you haven't defined the territory for your license agreement, then it's assumed that the territory is the country where you entered into agreement. So this is like how they interpret it narrowly. Um, of course, in practice, usually we use like the vague provision stating that all the IP rights to this IP object or IP, all the IP rights created during employment uh, relationships and things like that are transferred. And then we go into details because uh, you want to make sure that it's like written, uh, like the transactions aim, like it's like defined. So moving on about licenses, then we have also open source licenses. And here I just wanted to bring your attention to the fact that we have two types of them. We have permissive licenses and restrictive licenses. And when you use those for your, I don't know, product or you want to create something using open source code, then you have to make sure that you use the license terms are the ones that fit your purpose. So permissive licenses are the ones that are flexible. You can use the code and you can afterwards own the actual like creation of your work, which incorporates this open source code. And so far so good. But when you use restricted license open source, then it means you have to give your creation back on the same terms you got it. So if you take it for free, you have to get it back, give it back. So it's also good for some other, like I don't know, like when you want to own your creation, then you restrictive licenses won't work very well because most likely, if you don't want to share that it will be subject to litigation. I don't know, or contractual penalties. Um, and then this was about licensing, and now I briefly would like to cover employment relationships and bring your attention to the default rule that we have for copyright. Um, so the default rule is that if employee creates something during employment relationships, then he is the owner. He is the owner, and the employer has only the right to use the creation or the work of author. Employer, I mean, and so yes, employee is the owner of rights, but the employer has the right to use, and that's it. So if you want to be it otherwise, you have to state it in employment contract or specific contract, but you have to make sure that there is this transfer of ownership. Uh, but good to know that for computer programs, we have other default rule, which is like the opposite, stating that for computer program authors, um, so basically employer owns the computer program, the rights to computer program. It's an exception, but for other types of authors work, uh, you have to make sure that it has been transferred. And it also applies to work, like commissioned work, and even to founders, because if you are two founders and you create something together and you have like your startup is a legal entity, there is no like automatic transfer from natural person IP rights to the legal entity. So therefore you have to make sure that everything is the way you want it to be. Then about also trade secrets, which is a bit peculiar type of intellectual property, because trade secrets actually are not limited in time, but they have to be secret. I think the most popular example here is Coca-Cola recipe. That's a trade secret. So trade secret is we have a special law for it, and it has a legal definition. And in order to something be a trade secret, it has to meet this definition. Namely, it has to be undisclosed information of economic nature, technological knowledge, scientific or any other information, which has to meet three criteria. It is secret, it has commercial value, and the owner of it has taken appropriate and reasonable steps to make it secure. So if you are not diligent enough and you are careless, then and you don't take appropriate steps, usually companies do, to protect your trade secrets, then it may not be a trade secret anymore, and then it won't be protected as such. Then probably when you read NDAs and confidentiality agreements, you have came across definition confidential information. So this is like a contractual term which tries to make the legal definition wider. Uh, so confidential information is trade secrets and something more. Uh, this definition is included just in case something is not qualified as trade secret, in case there is dispute in a court. And then you create your confidential information definition. You create your own rules in the contract, and then the parties are both binded by these rules. And NDAs and confidentiality agreements are the legal tools how you can protect your trade secrets and confidential information when you have to share it with business partners or something like that. But of course, you have to also implement like actual physical security measures like access restrictions and things like that as well. Then moving to the final slide, I just want to sum up the key takeaways from this information, namely that as startups, most likely intellectual property is your main asset, so you have to be diligent and treat it very carefully. And of course, it's good to start managing IP rights before they exist. This is like maybe sounds weird, but actually, um, it's better to have an agreement in place before something bad happens. So when you have created something already, and then you try to make a deal with someone and divide ownership, then it can become problematic because, I mean, um, yeah, then you already have a problem, most likely. Oh, you don't have to be a lawyer to say that you have to read agreements, but this is true, and unfortunately, it cannot be avoided. But it is important, especially when you use third-party IP rights. And then, yeah, IP is territorially restricted and limited in time. That's also important to remember. And I didn't mention at the beginning, but ideas cannot be protected as IP. And this might be more important in terms of hackathons, where you go and share your ideas. So technically, afterward, afterwards, anyone can take this idea and use it because it's just an idea. Um, IP laws protect like actual works creations and for like something has to be created, and the proper management, that's also like advice. So you have to be you have to know what you own. You have to be aware of on what terms you use third party IP rights, and most likely you also have to be aware how others use your IP rights. And if someone uses infringe your IP rights, then you have to react. At least send cease and desist letter, but generally you have to follow what happens. You have to register everything you want to be protected and owned. And yeah, that would be like the key takeaways. We will have like a Q&A session afterwards. So now I will give the floor to my colleague Krišjānis, who will cover the other topics for today. Okay, thank you.
Okay, thank you, Yanni. Hello, everyone. I'm Krišjānis. I'm Certified Data Protection Officer and Assistant to Attorney at Law. And today I'll talk a bit about data protection, about artificial intelligence, and overall some general technology-related laws. There is quite a lot to talk about, so I'll try to make it as quick as possible and try to give as much information as possible. Uh, so you could maybe implement it or somehow improve your internal privacy or etc. in your company. So uh, don't be scared. Initially, it might seem challenging at first, but I'll try to explain it, and a lot of things can be done and improved on your own. So at first, I'll talk about personal data protection. As you all know, there is this big EU law called General Data Protection Regulation, GDPR, and mainly we will focus on that, since there are also locally some laws which also apply. For example, if you provide services to patients or you process health data, there are patient rights law, and there are other laws in relation to judicial processes and etc. So initially, I think we should understand what is in accordance with GDPR personal data. So typically, we also all know it's name, surname, personal identification code, etc. But we should always look in a uh, wider range, that it's not simply that, it's any information which allows you to identify someone or some individual. So maybe someone knows what's in that picture. No, no guesses. There's face hidden. Porzingis, yes. He's a basketball player. So even though you did not see his face, you can already, by some other means, identify him, which might be, is his occupation. He plays basketball. It might be his number on a shirt. It also might be his skin color. Also might be because you maybe know me, and maybe I will put some Latvian guy on the presentation. So there is a lot of things which would allow you to identify an individual. So it shouldn't always be looked down as this narrow scope. So always think about that. And then there is this, according to GDPR, what's not personal data. So when these laws and regulations do not apply, it's when data is anonymous, so you cannot tell whose data it is. For example, if you tell, oh, he's lawyer practicing data protection, it's a bit vague. You would not tell who that person is. If you say he's a data protection officer from Sorainen, that's already not anonymous because you can already start identifying that person. Same would go for deceased persons. If you are dead, you have no data. Your data does not matter, but as long as it doesn't affect your relatives. So if you process some genetic data and maybe it could tell information about relatives, then it could be considered personal data. Same with legal entities. Legal entities are not natural persons, and uh, data protection rules do not apply to information about legal entities, their representatives, etc. And also when it's not organized. For example, uh, you cannot ask someone to delete data what's in your head. You can try to hit him really hard, but it would not work. Um, so GDPR does not apply when it's not structured data. When it's in your head, maybe you are thinking, or maybe you cannot relate to anything. In those cases, it would not apply. And same if you are using it for household uses. It's not professional, you use it for yourself, and in those cases, regulations would also not apply. So what is processing? It's basically every action with data. It's when you ask someone to give you data, it's when you store it, it's when you send it to someone, it's when you use it for your services. Pretty much any action with data is called processing. And involved parties, who are mainly involved. One thing is data subject, which is basically all of us. We are all data subjects. Our data is being used for some purpose. Some company uses our data, or we provide our data to receive some sort of services. Then there is controller, which is basically the person who is mainly responsible regarding all these data processing activities. For example, it could be a startup. If you provide services to someone, you request their data in order to provide these services, and you tell what you know, and you decide how the data will be used for those services. In those cases, you are considered a controller. You control this data and you use it for your services. Then there is a processor, which is an entity which provides support to this controller and who does tasks on behalf of the controller. For example, uh, you are a controller, you provide these services to clients, but you also get processor, which could be a cloud storage provider, which could be some CCTV video security around here, because you tell them what to do, but they do these tasks on behalf of you by your instructions. And same with IT system maintainer. For example, if you do email lists, there are companies which are processors. You provide emails to them, and they will send out emails to these clients, etc. So these are the parties typically involved in data processing. And you as a startup could be either a controller or a processor, depending on what kind of activities you do. In some cases, you could be uh, a controller, but if you, for example, your startup is a service which supports companies, or maybe you provide the storage or maybe AI solutions to company, you could be considered processor for that. And when there is a processing, there must be purpose. You cannot simply process some data just because you can. You must have reason to process it. So it can be only achieved if you have this purpose. For example, email marketing, you request email to for what purpose? to send marketing communications to them, for example. And in that case, there is a purpose for this uh, request of email. And always you must think of purpose. Why do you need this data prior to committing this processing activity? And if there is a purpose, each purpose, for example, you want to send out emails, etc., that you need a legal basis. So for each purpose, you have to use this data. You must have some basis where you can, uh, why you can legally do that processing activity. And there are, according to GDPR, there are the legal bases are mentioned here, but also if you are processing some sensitive data, then there is also more restrictive, some a legal basis. So first one is consent. Typically, anyone can consent to anything. It's the last resort if any of the other legal bases don't work. For example, we all know, again, email marketing communications. You give consent that your email will be used to receive marketing and other emails. Next one is contract with data subject. It means when you are providing services, you need that data to provide this your service according to this contract with data subject. That's another legal basis. Then there's legal obligation. It's when law requires you to process that data. For example, regarding employees, employment data, etc., you have obligation to keep that data and process it. Then there's vital interests, which is typically used in healthcare, but also maybe with CCTV cameras that they are recording to protect your vital interests, health, etc. And public interests, which are typically for official bodies, and legitimate interests, which are uh, certain cases when you think that your rights as a company is more important than data subject rights. For example, if you need to keep proof for civil matters or civil dispute, you need to keep this proof. Okay, we need to keep this conversation since we have a right to protect ourselves in court in case there is a dispute. So in those cases, you outweigh and do this assessment that your interests outweigh the interests of data subject. And the requirement is that for each processing activity with purpose, you must have one legal basis, at least one. There could be many for one, but you need at least one, so it could be legal. And overall, generally, all your data processing must comply with general principles, which is they must be lawfully, fairly, and in transparent manner. They must be specified that you cannot uh, uh, suddenly you process data for one purpose and then you decide, oh, we can use this data for different purposes right now. We got email, we will send marketing communications, and yet we use the same email later on for different purposes, which would not be allowed because that's not how you initially gathered this data. And also data must be accurate and in order to achieve those purposes, which is data minimization principle, that you don't ask more data than you actually need. If you need some data, you won't ask in addition to your email address, give us your gender, your weight, your family names, etc. Because you can ask it, but you don't actually need it. In that case, you cannot use it. And next principles are accuracy, that your data is kept up to date, and storage limitation, that data is stored as long as necessary and only once to fulfill this purpose. And confidentiality, that its data's integrity and confidentiality is processed. So this is a general overview over like general requirements of GDPR, but I think we can just see in practice, maybe to a bit easier understand uh, how does it work in practice. So typically how I judge companies as a data protection officer is by opening your websites, and on initial look, I can already tell how much work I have ahead of me in regards to data protection. Since website is basically a business card for your company. So it's quite important to also have your website in accordance with privacy principles, since similarly, authorities also would check your website first and see, oh, it's so bad, there must be some fixing to do there. So we will go through some things which typically are not correct in websites and see what you could do and improve. So first one, you typically, as a data subjects, already know and seen cookie consent banners. You hate them, I hate them, everybody hates them. They always pop up and don't let you go check the website uh, since what since there are problems with the banners. So typically in practice, all these banners or cookie notification banners, typically you think you have a choice, but in practice, in 60% of cases, there is a cookie banner, but cookies are technically already set on your device. So whatever you decide, it's quite pointless because they, on paper, have this banner, but internally, when you check the website, cookies are already set, they are not blocked. So always check that first, that you actually are blocking cookies with that cookie banner. And cookie banner is a typical example of, as I mentioned previously, these legal basis. One of these legal bases for processing is consent. And the cookie banner is typical example, since you consent to something, you agree or disagree. I want these cookies in my system or I don't. So there are requirements. It must be freely given, presented in a way that distinguishes from other issues. So it's separated, you know to what you consent. There is clear and plain language, you can easily understand it, and it must be obtained before or during processing. And the important thing is that it must be revocable free of charge. So there is a problem with consent. Other legal bases do not have this problem, but if there is something, some processing done on the basis of consent, there must be as easy way to revoke it, withdraw it, so that the person has the right. So if he consents, he has this right and easy opportunity to withdraw it. And cookie notice is the first thing that appears. So good practice is to actually have it on in the middle of screen, in somewhere where it's easily noticeable. It's not hidden somewhere at the bottom of the page. So the user actually sees the banner the moment they enter. And the goal is that they indicate do they want cookies or don't, and after that they can view the website. So it's not that you are already processing or cookie banner just stays there on the bottom, or they just click around and already do actions on the website. So there are things to keep in mind in general formatting, placement, and wording rules. Uh, it must be clearly visible, and best practices that users should not be able to do other actions while they have not decided regarding use of cookies. And in cookie notice, what you must do is briefly explain the purpose of setting cookies. It must be provided in easy language, uh, must make it clear what would constitute as consent. For example, if you click accept, it would constitute that you accept our cookies, etc. So it could be clearly understandable. And the reference to cookie policy where there is more detailed information, and there should be some information regarding cookies use, etc., and so on. One thing to keep in mind, whenever you are not on, whenever you are interacting with users, it doesn't mean always in website, but also apps, etc. There are so-called dark patterns, which European Data Protection Board mentioned as interface or user experiences implemented on platforms which lead users to some unwanted or unintended decisions or somehow impact their behavior in a way which would go against interests of the user. So here are some examples. It's downplaying negative information. It's requiring the user to opt out. There is some checkbox inserted, and they ask you, okay, we did it on your behalf. Hopefully you're okay. No, it should not go that way. Or maybe cancellation is difficult. There have been sites, I'm not conspiracy theorist, but well, one site was working really well. I was on the trial, and on last day of trial, suddenly website starts logging, it closes off, there is 404 error whenever I start clicking the cancel button, and it went so far that I couldn't believe it after a month of everything working well that suddenly it starts working so bad at that moment. So you should not choose that or do anything in regards to that. Then there is buttons which are emphasized in a way which do not support this intention of the user. You can see it a lot in cookie banners. When there is one button really highlighted, accept, 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 and sometimes there is not even a decline button or it's hidden somewhere. So you should not uh, implement your cookie banners like that. Then there is text deliberately changed by color, size, emphasis on some kind of words. There are some interactive elements or toggles which are hard to understand or hard to undo on purpose. And there are company section listed as default choice without the consent of the user. So these are not legally enforceable. However, they are looked down upon. And if you are presenting or using these dark patterns in a negative way, which could impact the user, you could also be liable regarding these. And in regards to cookies, as you, the cookie banner accept and reject button should be the same size. Uh, you should not put a agree button or, as you can see in the example, they must be identical, agree and decline, and so on. And cookie policy must briefly explain what cookies are used, indicated storage for cookies and description, what kind of third-party cookies are used, for example, Google Analytics, Facebook, etc., and information and how to remove cookies. Good practice would be that you have a tool, as mentioned, for consent. You must be able to easily withdraw your consent. So if you are asking to one click of a button accept, you should be able to reject these cookies also as easily as you agree to them. So there is these tools that on the side of the website where you can change your cookie settings. So that's a nice tool to have. And website registration forms. So there is also a big problems in regards to that, since quite a lot of times it's unclear what kind of information you are asking from users. So there could be situations where you don't actually need that data uh, for your services or your company, etc. So you should always indicate which data is mandatory and which you need for these services and which should be optional, and users could decide if they want to or don't want to provide it. And yes, there have been seen places where they just ask gender, interests, etc., just because they can, but you should always keep in mind those principles I mentioned at the start, that you should minimize the data you use and only use that data which is absolutely necessary for your services, and try to process nothing more. Same with newsletters, email, and marketing, that all the communications must have separate consent. You cannot simply, if a user registers to your website, you cannot simply ask them, okay, you are registering, you are also agreeing to our communications, emails, newsletters, etc. It must be a separate consent. As mentioned by criteria of consent, also agreeing to email marketing, it's on the basis of consent. So it must not only be easily, it must be separated from all the other consents, as here is one bad example where everything is mashed up in one checkbox, and by one checkbox you basically agree to everything, and you are kind of forced to uh, agree to receiving marketing communications, which is illegal according to GDPR. And whenever you provide these marketing communications, as mentioned, with consent, there must be an easy option to withdraw. So you can either, if there is a registration, provide an option to cancel these newsletters by in profile. Typically, there is hyperlink within communications at the end of each email. So every time a user receives some information, every single time you must have an option to unsubscribe, etc. Since, as mentioned regarding consent, it must be easily withdrawn. And same if you are providing some marketing by number or sending SMS, there must be at the end of each message an option to unsubscribe. And a lot of problems which arise in regards to user uh, profiles, etc., is that a lot of companies, they build their company, they build their website, and in the end they notice, okay, but we have not provided any option to delete your actual account if it's not needed. So it's quite typical, and you should also always keep in mind by keeping this privacy, so-called by design, that while you are developing your programs, your apps, your websites, you are keeping in mind, okay, how will users react? How will they manage data? And it would be the best if you already start thinking about it in the beginning. And one of the main documents is privacy policy. Uh, Basically, privacy policies must be short, transparent, easily accessible, and actually lawyers are probably the worst people to provide or prepare privacy policies. Lawyers are excellent to review them, but actually lawyers tend to write everything. Nobody reads those privacy policies because there's so much information. It's such the, every single word is written in such a non-informative way. That's why typically the best way would be, because privacy policy is basically not as much legal document but more informative document. What your company does, what you can do regarding your data. It's explanatory. So you should also treat it as such. And it must be in clear, easily understandable language. If there are children processing involved, it should be written in a way that's addressed to children, but it's also good practice to generally write policies as if children are reading them, because it just works for everyone better. And it's basic also data business card, your privacy policy. Oh, it's not only your activities on your website, but generally what you do as a business, etc. And there is already within GDPR requirements what should be mentioned within this policy, but it's information about company, as mentioned previously, purpose and legal basis for each processing activities. So, for example, we use your email marketing. More purpose is to send out our newsletters, and legal base is your consent. And storage would be, for example, we will store it until you withdraw your consent, or when we probably don't plan to send newsletters anymore. That's typically how it goes. Then there is legitimate interests. It's another legal base. So if you think you will process some data on this base, you will also have to mention it within privacy policy. uh, who receives the data, transfer of personal data to third country, if there is any transfers, how long data will be retained, uh, information on obligation, if there is obligation for users according to laws to provide, for example, if there are anti-money laundering requirements, etc., that you check your users and then you mention it in privacy policy. And if you make automated decisions, then also regarding that, and rights of data subjects. Here are the rights, it's access, that user can confirm that you are actually processing, because user might not know that maybe you have data. So they have a right to ask, do you have any data regarding me? And that's one of the rights. Then rectification, if there is some mistake, there is wrong email, etc., that's your obligation to do that. Erasure, if there is no legal basis to process this data, user can request to erase it. Restrict, object, and also portability, which is not typically used, and it's quite a specific right which might not apply. And then there are some not really um, some a bit more unknown rights, which, as I mentioned, is right of withdrawal, which is also considered right in regards to consent, and right to lodge a complaint to authority. And to sum it up, we went through the websites, and now in regards to general compliance of the company, because with website documentation, there is already a lot of done, and it's already business card. So if your website is okay, it should be fine overall. So the first step would be to identify product-related data and map out what data you actually process. Then would be step 2 would be to check if you can actually do it. Is it legal to actually process all this data? Then step 3 would be to prepare all the documents, technical aspects, prepare necessary procedures to process all this data. And step 4 would be to plan long term and plan all these tasks. And maybe through the steps, first is prepare a description of your product. Is it innovative? What will be used? How it will be used? Will there be any specific technologies used there? Who will be your target audience? If it's legal entities, as mentioned before, legal entities are not, information about legal entities is not considered personal data, so a lot of rules would not apply in those cases. Then identify types of data. Do you have your client's names, surnames, IP addresses, using cookies, maybe payment information, and whether there is you have access to some special category data which requires some tougher restrictions or rules for that. So it's race, religion, health data, and fingerprints. And also describe what do you do with that data, what kind of process you do. Is it you just take that data, or you maybe arrange it or send it or transfer somewhere, and check who is involved. If you get a CRM, if you have cloud service providers, if you use any AIs, etc. So who are these parties? So and also are you is data being sent away to some countries outside of Europe by these third parties? And also assess if in these activities are you controller, or where you decide how this processing will be, or if you are a processor and you assist someone else, another controller, with their processing activities. Then step 2 would be to overall see if you can actually do what you do. So it's understand what kind of data and from where you gather it, that data, purpose, why do you need data, all that data, is there a purpose for that data in your business? Then organize all the sources, categories, and purposes in a way, as mentioned, in email marketing, etc. Uh, Assess if it's necessary for the activities and identify if there is legal basis for each of the purpose and data processed, and ensure there is a lawful basis for all that, and data subject rights can be enforced. As mentioned, that the subjects can actually request to delete data, request to do other activities in relation to that. And step 3 would be already implementing all the documents and policies, which would be preparing privacy policy, data breach response plan. For example, if something happens to data, what will we do? Because that's a really delicate matter. So you must have already something in place prior to it happening, because in those cases, all the situation can get worse. And create a record of data processing activities, which is basically a massive Excel file where you list, okay, we use for marketing, we use email address, we get this email address from this client, and we have this purpose for processing, etc. So basically, all these chains of these data processing activities with information is available. And a lot of these documents can be found online, because the general data protection regulation already tells what you have to have in these documents. So in all of Europe, they are quite similar. There are um, some smaller things which differ, but generally they are quite similar. Same with data protection policy. And next is to check you have actually agreements in place with your processors. For example, someone who provides your cloud storage, someone who is a processor to you, or you use them for your business activities. You must always check if you have agreements in place with them, where, because you are responsible as a controller for the processors or these companies you use to help with your data or your customer data. So you are responsible, and it's necessary that you keep your processors in check, and best way would be to have this agreement with them. There is also data protection impact assessment. For example, if your data processing is innovative, or maybe you use AI or some other things, that you might have to make this assessment and to see if it's actually possible. And also some internal procedures for monitoring incidents. And last step, which is long-term thinking, it's already updating and reviewing policies, it's training your staff, and it's engaging some experts, someone who knows to review your policies. Maybe you have all of them prepared, but maybe have someone check, maybe you have something essential missing there. Okay, so I think we, in regards to data protection, that should be it. There will be later Q&A. Within time, we are managing it well. So uh, I think we will go further on to artificial intelligence. And in regards to AI, the legal framework is quite uh, all over the place. So we all know there is this Artificial Intelligence Act, which is quite recent, most recent law in Europe and overall worldwide. But then there's also a lot of interactivity between AI Act with other laws. So it might seem messy, but depending on how you use these systems, it might vary, because if you are developing AI systems, if you are using them, or you are uh, using these systems in interaction with clients, then AI Act will apply. If you start processing personal data within AI systems, then general data protection regulation would apply. If you are marketing or maybe using images by AI and using it in marketing to consumers, which in those cases you might breach some requirements in advertising law or consumer rights protection law, or if your database AI is trained on images which do not belong to you and you provide some sort of image or something which breaches the copyrights of other IP owners. So there are a lot of these risks, and AI regulation does not apply in certain cases. There are exceptions. Similarly to GDPR, for non-professional activities, it does not apply if you're using at home for your personal needs. If also, it will not apply if it's outside of scope of EU law, but it would be in cases when you do not provide AI services to European citizens. But typically, EU laws have this thing that they, in a way, always make companies, in a way, comply to them because EU market is too big and people want to provide services to EU citizens. Thus, these AI Act requirements would apply. And exceptions are military defense, law enforcement, or judicial cooperation, scientific research and development, and if you are using systems under free license or open source licenses, except in high risk cases, which we will also talk about a bit. And to whom it applies? Basically, it applies to a lot of parties, mainly to all the parties. I will explain why. So first off is AI providers, which are entities or persons who develop AI system, or if they have, or they place it on the market. They have developed it elsewhere, and they are placing it on market in Europe, or they are using it, they are taking some other service and they are putting, or some other AI tool, and they are rebranding that, for example, open source AI tool, and you are rebranding it as your own tool with your business name, etc., then you would be considered an AI provider. In regards to AI deployers, those are basically users. That's everyone. So AI Act applies to all the users. That's use of AI system in the course of professional activity, and not only, also in cases when these results from AI are available to people outside of your immediate group of people, or publicly somewhere available. In those cases, it would also apply to you as a user, even if you are not using it for professional activities. And also to importers and distributors. That's in other cases when they are taking some AI system from outside the EU and they are starting to provide it in European Union. So there are a lot of requirements for these providers, which is ensure compliance with systems, data quality and management, cybersecurity requirements. There must be some sort of system for these providers who actually develop these AI solutions to have quality and management systems, so they can check if these systems are actually working, if there are no hallucinations, etc. So you could check, and you have this procedure in place. You must also maintain documentation regarding the system if you are developing this, and also log files. So what has this system done, etc. Also assessments must be done, serious incidents must be reported, and also if you are using high-risk AI systems, we will go a bit later in a bit more in depth in different types of systems, but also you must register those systems. And if you are outside of EU, you must register in EU. And for the employers, that's when your company uses some other AI system you have not developed, or you are personally using some AI systems for your own sake, or if you are an uh, individual who does business activity, it would also be you. So you must uh, first off have these AI systems. Um, you have to work with these AI systems in accordance with instructions of these providers. So it would also be considered a breach if you do not have those in place. Ensure it's supervised, ensure that there is always supervision of the results done by AI. Then there is monitor of performance, keeping logs for at least 6 months or maybe longer, depending on what you can and how you can use it. Inform people that through privacy policies or whenever you are using those, that you are using AI and that some sort of data or something will be processed by data. And if you are using high-risk system, then you must also register. And in regards to systems generally, AI Act has developed this risk-based approach, which provides stricter regulations the more the system is high risk or could cause some trouble to the users. So there is unacceptable risk, high risk, limited, and no risk. So unacceptable risk would be subliminal methods of influencing subconscious or using vulnerability to manipulate people. So typically that would be maybe using a chatbot, or somewhere in close future we will be able to use AI agents and maybe use those agents or bots to speak with some elderly people or kids, or maybe trying to sell them product while AI tries to learn about them, uses maybe their age, maybe not understanding of questions, or maybe AI reads out, okay, this person has this post on Instagram, etc., and oh, he seems sad. Let's write to him, and maybe we can push him a bit more harder regarding our product, etc. So that would be unacceptable. It's social evaluation, how good the person is, how bad. So there should not be any processing related to that. Predictive policing, so that police can predict based on maybe your genetic data or other data available that you might commit crime or you will not, or how much of a risk person you are. Maybe you should go to jail already right now because our statistics say so. So that's illegal. Also extracting images from databases or CCTV cameras. So if you plan to maybe use a sell a cosmetics product, then you should not scrape all the Facebook images to see, oh, these are the persons we can sell this product to. So you should try to avoid using databases as such. And also emotion recognition is unacceptable, but there are exceptions, for example, where monitoring is required for medical purposes. So a patient sleeps and monitoring or video camera senses, okay, a patient is probably screaming, there is a problem. In those cases, it's allowed. And also biometric categorization, which is political options, religious or philosophical beliefs, or sexual orientations. You cannot categorized based on that data. Then there is high-risk systems, which are basically um, high-risk systems are systems which could impact all those rights which you have in accordance with Constitution. You have right for life, right for uh, just court, you have right for privacy, right for education, right for employment. So these are the systems where it must be sufficient guarantees must be provided that computer doesn't tell on behalf of human what you can or cannot do according to your constitution. That you cannot take, for example, this credit because AI system thinks so and decides, for example, that your uh, data is analyzed in a way when it could impact your livelihood. So these systems are under regulatory scrutiny, so more checks must be done within these systems, high-risk systems. And as mentioned, there is a lot of requirements for such systems, which is risk management, data quality, technical documentation is needed if you use them, accounting and recording, that you can follow what kind of decisions were made by this system, etc. Human monitoring, that there is always human interacting and overseeing the activities done by these high-risk systems, and that these systems are actually accurate and secure. Then there is a next stage is limited risk systems, which are the systems we typically use, maybe as individuals, which are when you are directly interacting with the individuals, which are chatbots, etc. Synthetic generation of audio, video, or images, which are which we might use for marketing materials, etc. Emotion recognition systems, manipulating images or audio, which are also known as deepfakes, or creating or publishing text. These are limited systems, and for these systems, there are certain requirements in regards to transparency, since it's typically users that interact with such systems. So these users must always be sure and always be informed that the systems they are interacting are actually AI. So you must be transparent, whether it's the chatbot, whether it's image or publication on your website. You must mention that, okay, this is generated by AI. So it's a requirement for you, not only if you are doing this as a business, but also GDPR, or I mean, AI Act applies also in those cases when you are just a user and providing this to someone else to see. So it must be always transparent, and typically it's um, fixed by labeling, that you are either prompting uh, and mentioning that it's created by this and that tool, and it should be good practice, for example, if you are using images, that you save those prompts. For example, if dispute arises, maybe the training data was using someone else's IP. So in case of dispute, you could maybe tell that, okay, either we generated this image or it was the fault of the AI provider, that they used all kinds of restricted IP materials for generation, etc. So transparency is quite important. And then there are minimum risk systems, which are basically systems which do not cause any meaningful problems or distress to users, which are filters in video games. So in those cases, the rights are not affected of the users. So how can companies prepare for AI Act? It's similar to GDPR, mapping, understanding what kind of systems we use, and then identify if these systems pose high risk, limited risk, or minimal risk, and after that, imp improve the requirements and prepare documentation or inform users regarding use of AI, etc. So mapping, see, what important would be is to make sure you read the agreements with the AI software providers and see whether they are using data to train their models, whether the data or information is sent to somewhere outside of EU or European Economic Area where there might be restrictions to sending your or your client data somewhere outside. So it must always be uh, sure and also assess risks. Would there be any problems if we use any data or if it's processed in uh, any way? And have this management system. So who reviews what kind of system is used, may have internal policy, so at least employees or you would know what kind of systems we can use for business purposes, what we cannot, and so on. And maybe in the end, we could talk a bit about IP. Colleague already mentioned IP in context of licensing, etc. So in regards to IP, we could talk about AI, who is the author and who owns the IP of something prepared by machines. So theory and idea is that only a human can be an author and machine cannot be considered an author since that's a thing only a human can do. So here is the image of macaque. There is there was a case some time ago, pet protection agency PETA sued one photographer since he took the rights of uh, since he was considered the author of this image. Pete argued that this image, well, author actually is this macaque in this image since he took the photo, but in the end, court argued that no, it was the human who set up the cameras in the spot. The human was that who got friends with all these macaques, and human was that who left the cameras there so macaques could take them and take a photo. So it's always humans who interact. So one moment. So basically, how it goes is that uh, humans are responsible for algorithms within this AI system and developing of those, but results and for those results, and it's never the system. It's always human in one way or another. Yes, there was a question. Well, it was, as far as I know, it was in U.S. case. So there are a lot of cases which go to Supreme Court there on different reasons, but it could be that some cases go through because it's interesting topics. So, who is it? Only human who can create this derivative work or etc. So how it went there, it's hard to guess, but at least we can talk and we can, with some certainty, say that that macaque is not the author of that selfie. So yes, it's precedent based, complete. So if they have, yeah, and it's a precedent, so it would not apply directly this judgment to us, but principles are similar. So idea is good. So I think that's it from my side for today. I think we will go into lunch, and after that we have Q&A session where we'll also be joined by some of our colleagues.
Yes. Thank you for the recording in progress. All right. So we have 20 something students online, and we have 10ish students here. So now we have a Q&A session. So please be ready to ask your questions, specific questions that you might have to our esteemed guests here today. Two of you of whom we already met, and we have also Ramona joined us. Maybe you can just give a quick intro.
Hey guys, I hope you hear me well. So I'm a partner at Sarainen. Joined a bit more than 1 year ago. Before that, I was a partner in several boutique law firms with a focus also on startups. At Sarainen, I'm the co-head of finance and insurance team and heading startup and venture capital sector group. So I've been working with venture capital funds from 2007, and so a lot of experience with working with different kind of startups, and I'm really happy to be here. And to be honest, startups and venture capital is sort of my thing, and I really like working with you guys and inspired from you.
Awesome, great to hear that, and thank you for joining us today, all of you. Okay, so we're kicking off the Q&A part. I wanted to say that those of you who are online, please just unmute yourselves and ask the questions. I think it will be better interaction than writing in the chat. Do we have anything in the chat already, or?
Those who already wrote something in chat, unmute yourselves, ask questions. Let's make it as a discussion rather than just in a Q&A.
All right. So I think what we can do is, like, if you have a question, you can put your hand up virtually in on Zoom, and then so that we don't have two people asking at the same time, and we'll kick off like that. But we have a question here. Jānis, you have a question, and please, here's a mic. Please feel free to ask.
Yes, uh, I didn't participate, but the artist sent me the excerpt from darba devēju uzdevumā radīts darba autors, no darbs. Es atvainojos. And the question is about the second exemption about software development for employer, and there is stated that all the code which is made for the employer belongs. I'm not interested in autortiesību. I'm interested in this code.
So not copyright, but ownership of
Ownership,
the.
yes. And by default, it belongs, as stated, to this employer. But there is mentioned there could be another case. Can you explain what another cases, or how it could be arranged, or in practice, how it is arranged in practice when this coder or programmer or could be like owner too?
So about this, it's section 12 of copyright, and this second part you just referred to, it's not about the code as code, it's about the rights to code, the economic rights. And yes, as you mentioned, the default rule is that you employ a person as an employer, then you own the rights to the code. And if you want to do it otherwise, you have to agree with your coder that the coder will be the owner, or if you are the coder, the person who is the author for the program, then and you want to keep it, then you have to agree with your employer.
So separate agreement should be done.
It could be separate. It could be your the one only employment contract, but you have to agree on that somewhere.
Okay, may I add a bit from practical view? So what I have seen from a lot of startups, that initially you don't have any employment agreements with your coders. Yes, so basically all the developed ITs are not protected, and the author owns these economical and personal rights. And to be honest, this is what all the venture capital funds evaluate, and this is the key aspect that is reviewed during due diligence before investment. And basically, all the coders and all the founders should sign IP transfer agreement usually. And I haven't seen actually in my practice a case where the coder or employee would hold economical rights to the developed code or IT system or components. So then most probably this coder should be a founder of the startup rather than the employee.
If, yeah.
But
Please.
technically, it is possible. But practically, probably, yeah.
I can maybe share from my experience when building a startup. So essentially, we were paying even the co-founder, the technical co-founder. We were paying a salary from the very beginning. It was a small one, but we were paying something, and we had an agreement. And an agreement. I think back then maybe it was not the law that it belongs to the company, or maybe we didn't have like official employment agreement. So we had an agreement where it was said everything that you code that we paid for, it belongs to the company. And even if you are a founder, what you get in return for your job, for your work, and for the code are the shares of the company, but the code should belong to the company because investors will check that and they will not invest if it's not done correctly.
Because for startups, your product, your IP rights are the key. And if the company does not own it, then it's just a registered legal entity without anything.
Did that answer your question?
Almost.
Almost. So if you want to do it otherwise, you have to agree upon that specifically, and you have to have a very good reason why you're doing that. For the company's benefit, the code should always belong to the company.
Okay, maybe in short, because in Latvia, let's say, I don't know, in other countries, there is the companies do not want to pay you. Let's say if I'm like in not in a startup or I'm joining for a time for a startup, they want to pay you in specific way. They do not want to have company agreement. They want employ you. Otherwise, it is complicated for them. And then if I'm coming in as a co-founder, but they want to pay me as a regular how you say, then it is a problem. I'm losing my rights. Let's say I'm downgrading my intellectual property.
No, but if you are a co-founder, you own part of the company. So through owning part of the company, you own the code.
Okay. Then maybe it's a way you need to. Okay. Thank you.
Okay. Please come with more questions. Yes, Konstantin, I'll give you the mic.
Hi, I have a couple questions. First one is about AI. So we use a lot of AI in making prototypes for a product, and I believe there is a chance that this AI might use some code which might be taken or IP secured from another company. Was it in your experience, or you maybe have heard something like that, and what kind of risks there are, and how can we secure ourselves that we code something with AI and not getting sued later that actually is property of someone else?
So from practical perspective, a lot of it depends if you are in trouble. It depends on what kind of data has the AI model been trained on. So it could be problematic if you are getting some sketchy AI model from who knows where, and they are training their inputs or maybe their coding language, etc., on somewhere where from existing already websites, programs, software. So it's quite hard to follow that currently, since even the AI systems do not know if that code they are taking, if it's protected or it's not. Personally, I'm expecting already there are some models in which you input some data and they can tell if that, for example, with images or artworks, etc., there are already models where you can input this code or this image and they can tell if that image is already protected or what's it been trained on, etc. So I'm guessing similarly for software, etc., there might be AI tools sooner or later where you can input all these codes and they could tell or search the data, because AI could tell if it's generated by AI or they could find it somewhere on the internet on their own. So maybe that could be a better practice, because currently there are no such tools that you can for sure check, okay, we are okay with using this image, this code, etc. And also sometimes it's quite difficult to also to protect the code. So there could be variations to it, etc. So it might also, maybe there are some similarities to some other codes out there, but still it's in a way changed or modeled which would not cause any problems. So currently there is no like definitive way. There will be soon probably ways to check it. Similarly, how in universities they are already checking if it generates. So with software, etc., it could be similar. So
Okay,
yeah.
so the short answer is at this moment we shouldn't worry about a lot, but later on when such tools will be already, we should try to use it and to secure ourselves, right?
Well, you should also worry about it right now.
I am, so that's
It's
why
a bit
I'm
more
asking.
difficult to be sure about it, so it must be always checked. Maybe you can search on your own if Google results find something similar, or maybe they got code from GitHub, which could be usable for further use typically. So there could be ways to check it. Just in a way, some sort of reverse engineering in a way that, okay, they give you a code out, so you ask them back, is this actual, where did you get all this code? So maybe rechecking and maybe talking to the model, how did you get it, and just to be sure how it got there. So if he generated it on its own or he got it somewhere. So
Okay, I believe it
Fun.
might be too complicated because our projects consist of, I don't know, hundreds and thousand parts of code from different, many generations of AI, etc. So, but anyway, okay, thank you for this.
there could already be so many modifications. Maybe
Yeah.
initially the code
Yeah,
was already protected, but there might have been so many modifications to that code that it's no longer that initial code,
Yes,
which
yes.
is under the protection. So it could also be that. Yeah.
Okay, thank you. Second question is about domain names, trademarks, etc. So we looked for, at the beginning, we looked for the best domain name which suits our project, for example. And we found them, we bought some, and then we discovered, oh shit, there is exactly company registered in United States with our domain name. So for sake of safety, we canceled this first idea and found another one. And well, it sounds good, it looks good. We checked, no company registered yet. So we bought this domain, we plan to launch it. At which moment should we worry about registering some additional trademark or something? So now we have only the domain name, but not company named or not trademark registered anywhere. So
Okay. Um, yeah, but domain names, they are registered on the principle first came, first served. So I don't know, even like you have registered your own, so it's good. Like you could be in trouble only when someone complains, but you already did the due diligence and found that this is safe. So I don't know, like so far so good. And when you're ready to register your company name, then you can do it. But I believe that company name will be different from your domain name as well
might
because
be.
they are not like equivalent. So I don't see really a real problem here, and most likely your trademark will be, I mean, if your trademark is like copy paste this domain name, then probably it would be wise to consider it. But on the other hand, there are already some protection to unregistered trademarks, like, which is a bit weaker than the registered one, but still. So yeah, I think so far so good. But I don't know. Do you want to add?
But did my logic was correct that we avoided that first domain name that had exactly same company name in United States?
Well, in regards to previous, not this question, in to domain names. So also it's important that you, even though it's not registered, the fact that you use it within your business operation, it already gives credibility that this domain was already, even though not registered, you are already in use. So in case you use not domain name but also business name, and if they are similar, they kind of support each other in a way. So if later on there is someone else who also uses the name, or maybe also is not registered, you would have more protection because you have this visible proof that you are actually using that name prior to all these later on registrations. So in a way, it also helps that you use it, and domain names and company names are also some sort of this property. So it's always nice that you, even though you are not registering it, it has some protection. So also using it only strengthens that protection in case there are further on some disputes, etc. And the second question.
Was our logic correct that we decided not to stay with the first domain name, although we liked it more, but yeah, we found that the company in United States registered with the exact same name. So
Well, first off, the thing is that also where do you use that domain name? For example, they are providing services in US, and maybe the domain name is similar, but their services are so-called
also similar.
also similar. Okay, that then it could be a bit more problematic, or maybe it could be a problem for them if you register that domain and name already in Europe, because as Lucia mentioned, the protection is within certain territories. So there could have been that they are in US, you are already starting prior to them registering in Europe, and then you would have this protection within Europe if you do that before them. But they could still object to it or something. So there could be some problems there, and most likely
So good
it's
decision,
better
right?
choice to just take unused because
Okay.
it limits the dispute.
Okay, again, I would like to share some practical experience recently with our firm. One of the founder, and this is a suggestion how things should be done with IP and trademarks. So the client who created the amazing idea, and he is actually the founder of one very successful startup. He exited, and therefore he knows the drill. He knows, he has experience, and he invented amazing idea, and the trade name or the name of the product is quite important for commercialization and etc. So what we did, he actually just provided us the information about the name and about what kind of services they are planning to offer. And then this is actually our business, what we are doing. We are making these investigations and analysis where which countries, what kind of the protection. Lūcija and Krišjānis can tell you more about it, but it is quite essential. And in the end, he decided, based on our analysis, to change the name because he understood that he won't be able to protect, and he's not he don't want to invest a lot of his time and everything in this trademark, which can be disputed. And I think there is also, even about the domain names and trademarks, there is sort of a business scheme for some companies. They are seeing some new companies, and they are registering domain names and then they are trying to sell them. Well, this is not what I recommend, obviously, and this is bad faith activities. But yes, unfortunately,
We
this
got
is a-
noticed that as well. So best domain names are used, and maybe only 10% of them are actually working. 90% of them are for sale for much bigger price than 10 and or $20. So yeah.
Yeah, I just remembered like a real life example from one of our clients, but the case was not about domain names, but they have this situation that they have registered domain name in Latvia, it's .lv, and then there is similar .ee like in Estonia, and they are not related, and then those companies get like calls that are not related to them, but to the other one, including me, because I googled the number and I called like to Estonian company because I didn't check. I just did it quickly, and then they told like this happens oftenly. So probably it is good to be different in terms of domain names and trademarks.
Okay, thank you very much. No questions. Next.
All right, we have another question. David, yeah?
Hello, everyone. My name is David. Thank you for coming. I actually have a question similar about AI. Our tool is also more AI agnostic. And while the models keep saying that they don't use the information to train their models, right? You can explicitly say so. I was wondering the best practices. So we are analyzing the tickets of the clients, the customer tickets, and while it would be a hassle to do that, but I was wondering if that would be the best practice to actually anonymize the ticket before actually sending it to the model, or it should be just if it's not needed, then we only if the client asks. So, what is your opinion about that?
So it's also partially data protection question. So what helps you if you anonymize data? What helps you is that general data protection regulation no longer applies to you. So anonymized data is no longer personal data. Thus, it could be used in any way you want, basically. So you could use any model you want. You could train it basically if there is no personal data. You can do anything. That model can be anywhere in the world, etc. The moment you use personal data and there is a possibility that model is trained on that data, or maybe that model is in USA or maybe China or somewhere else, that already gives a lot of problems to you. That okay, now we have a problem. We have to choose either models which are available within EU, servers are located within EU, then check if this personal data of those tickets, if a model trains on them. So if it's possible to anonymize, always do that.
Mm-hmm.
Since it gives less trouble for you, you are more free to choose what models you use, or maybe there is really great model. It's in a third world country, and it could be problematic. But since you have no data to train it on, it would not cause you problems. But the moment you use your model and you use personal data, you are kind of stuck within. Not really stuck. It limits you in a way, and you have to all have these procedures, inform subjects regarding use of their personal data, etc. So best recommendation would be always to anonymize. So
Yeah. Okay.
it would be just less problematic.
Got it. It might be a stupid question, but does the name actually itself, but you can't know that the person exactly by the name, and that I should ignore that. That's okay, right? If we send including the name. If
You
there's
mean
no way to impersonate the person exactly, yeah.
you mean would just simply the name, or
Yeah, let's say like an email where you have like David and no surname and so on. And would that
well, typical lawyer answer, it depends. So in a way, yes, if it's just Yanis at Gmail, then you it would be quite hard to address it to specific person.
yeah.
If it's for example email Yanis at So Rainer,
Yeah.
he would be already part of legal entity. So in that case, he can be Janis.Berzinch@gmail, but it would not be considered personal data. It all would depend how how much information is there to identify that certain person. If there is name, surname, and it's quite unique, like there are not tons of people with that name, it would be considered personal data. If it's sunshine123 at Gmail, then that's not personal data. So it would always depend, and you should also always check, okay, if is this enough? For example, if I Google this phrase, this name, surname, would someone pop up, and I could be pretty certain, or at least approximate, maybe add some other identifier, maybe you can tell, okay, the Gmail was used with same Gmail account by some person, then yeah, that would be personal data. So best way, if you do not need name, just act
Yeah.
it out, anonymize, and
Yeah, the problem is that we want to use the AI to anonymize as well, right? So, so, but probably.
there is an option to have internal AI
Yeah, yeah.
somewhere on internal servers.
Yeah,
Because
that
a lot
the
of
open source one, right?
yeah, open source, so you have it internally, so it does not send out data, or you can use it internally. You can set limits or criteria certain, and after your internal AI system anonymizes it, afterwards you can use send it to another system, and it's no longer personal data. So
Yeah, but in the start, it would be a little bit too hard to have an open source, right? Maybe
currently,
yeah, currently, yeah, at the moment. But maybe we can use European some kind of. I think Mistral was one AI model. Maybe we can use that model to evaluate if it's anonymize it and then send it to United States models. Would that work? That would be a better workflow for.
that would be much better because with data, well, it since you are still processing data with the EU model, you still have some requirements to data subjects. Okay, we will process, but at least it's within European Union. You are not sending data outside. There are probably some agreements with that AI model. Okay, we will not train, etc. And that should be fine. And afterwards, anonymized data can easily be sent anywhere you want, China or anywhere else.
Yeah.
Yes.
Another question, but the privacy policy, right? It's kind of our secret what we do and how we solve that problem, right? But to my understanding, we need to tell explicitly where that data is going, right, in the privacy policy.
Yes.
That there's no other way around it, right?
If there is personal data, so if you are using personal data for anonymization, for example, we are using this model.
Yeah.
And you could mention for anonymized data, we are using ChatGPT.
Oh, got it. Yeah.
Or so on. So because what's important for consumers or users that they understand how my data will be processed, and in regards to that, you must have everything in place and informed. So afterwards, once it's anonymized, that's no longer personal data. So privacy policy does not matter. Nothing, no GDPR requirements matter since it's no longer data. If it's truly anonymized, if it's just X and that's it. Yeah. In that case, yeah. But also, aim of privacy policy is not really to have all this legal information, but main thing is for users to be informed, so they simply would know. So even though we are sending anonymous data, it's not really personal data, etc. It still would be nice to inform. Okay, we will use anonymized data just in case, so they would know.
Yeah.
So it's a good
Okay,
practice.
got it. Really, thank you. Great answers. Thank you.
Okay, so our startup is more on the personal side. It's like a personal coaching slash venting out platform. And there are many considerations about the privacy. So for example, even if we have the user is maybe calling in and they're not saying their name, but they're talking that, you know, their neighbor Linda did this and then Andres walked down the street. How can we like what can we do with that data to still like have this privacy and be all aligned with the rules of GDPRs and whatever HIPAA compliance and everything around the world? Because would it be just okay with the anonymizing the names, but from the context, maybe you still could tell that it happened in, Riga Center, this street or something? Because it's all about you talk to the AI agent about your daily whatever happened in your life. So yeah, how can we approach it? Maybe you have some suggestions or something that we haven't looked into.
How does I'm not really understanding how does that AI system work there? It's uh, it's regarding some sort of chatbot or what?
It's a voice chatbot, yeah. So
Voice
you call
chatbot
it.
and someone. Okay.
Yeah.
Well, and you gather the data and you have that the
We
station data somewhere.
yeah, so currently we're using Company 11 Labs. So there is like the whole agreement goes like when they press it, it's all like okay. But then still, I would love to explain this to the customers and also for when in the future when we build our own, because 11 Labs is for the beginning for now. So what they do is you would call it. I don't see that you or someone else called, but I can see the conversation. The voice, I'm not sure. I think you can listen to the voice and then you can get the summary. But I don't know who was it who called, unless I give you just this certain model for you, because you can build like personas. So you call Andres, someone calls Santa, and then if I only give that link to you, so I know that's for you. But basically, no, because
And what's the purpose for this chat? What's the goal? Why they are calling?
they're calling to vent out, to tell their problems. It's kind of like mirroring back like a psychologist coach sort of a thing.
Well, then there is certain limitation of what you can do with that data, basically. So, okay, they are venting out, they have all these conversations, and they might give some additional data in that. In a way that one of the legal bases is that they consent. Oh, I want to tell this. I will. Similarly, how we give out business cards with our data, or
Mm-hmm.
by some certain action, same with calling and telling and giving that information away. If you have that information, it doesn't mean that you can actually use it.
Mm-hmm.
So if you do not need that for these venting out sessions, etc., okay, you have this data, they have given it to you, but that you have no real purpose to use it. So there could be limits to that. So okay, they are telling about some other people, etc., or something. It could still identify, but main important thing is to inform users that everything they say within this chatbot, etc., it might be recorded. Well, from this model side,
Do we have to like, because when they on the website, so we have the button, and before they are allowed to talk to it, it actually asks you to agree to the terms and conditions. And of course, it's explicitly because it's 11 Labs bot, it tells you what it, but nobody, because people come and ask, and it's like, what happens to this? I'm like, well, did you read it? No, I just pressed yes, as we all do. So yeah, so that happens. So then is the question again, like, what do we do with the data? So if we just delete the data after whatever 30 days, it's
if there is no business purpose, you must delete it.
yeah.
So if there is no use, if they give something additional, you have no reason to have that data. And
Mhm.
according to GDPR, you must minimize the amount of data you have if you do not actually need it. So maybe some retention policies, okay, they are having these conversations, we are deleting it. And maybe prior to starting this conversation, it might not be sufficient to just provide, oh, accept these terms. So you can read all these 20 pages of information, because it doesn't serve its purpose that they are informed. Maybe some inform these main points. Everything you say within this conversation will be saved. So disclose information at your own
Mhm.
um, risk, yes.
Mhm.
So where appropriate. So they are so you can prove that we are not requesting. You are just providing that
Okay.
information. we are storing it. There is nothing we can do. We will delete it after this retention period ends.
And
So-
if later we want to create, so at the moment, anyone can just open the website, they can call, we don't know who it is, but maybe later people want to create their own profiles. So these conversations are recorded, and then this model knows who is actually calling. And that is something that actually the users are requesting because they wanted to remember, hey, last week we talked about that, I want to continue the conversation. So what happens in those terms?
Well, it's quite similar since you just have to keep in mind that this data must be kept safe. If there is any model training done, users must be informed. It's like it's basically same data as user profile. Okay, in this case, user profile, there are also interests, these conversations, but similarly to all kinds of online shops, etc. There are also profile like products purchased, etc. So in a way, they could be treated in the same way as any other data processing. So yes, you are gathering this data through this AI model or through these conversations, and they are kept, but all this data must be secure. General requirements: do not send it somewhere outside of EU if there are no technical measures implemented, and so on. So in a way, similar principles would apply as to AI model and data generated by it as to any other that you
But
must.
if generally we're using 11 Labs, it's a USA company and they use Gemini or Claude for the conversation itself. We're already sending the data. Like it's like from the beginning of the
Yes.
conversation, it can't happen any other like at the moment.
Well, then also it must be prior to all these chatbots. Prior to that, they also must be informed. Okay, keep in mind your conversation data will be sent out to USA. So they could also agree, because basically, if they consent, if they agree, you can basically send the data and whatever kind of data anywhere they want. Main important thing that they are informed to what they agree. So yes, you are sending data to USA, but then you must also mention it, or maybe specific checkbox, which is I'm okay with sending my voice over data to USA. In those cases, it would be okay. If you cannot get that consent, then you must have a legal acts in place, legal agreements with that provider of models. So there are a lot of ways how you could get compliant, but it would depend on what tools are at your disposal at the moment. So
Okay. Yeah. Cool. Thank you.
Thank you, Monte. Yeah, that's David. Go ahead.
Yeah, I have another question. It's also, yeah, but it's kind of a little bit, I don't know, non-ethical. It could be like grayish type of question. So let's say I have a website and there's like some kind of free tool to lure the customers in, and it's also I'm in the back end. I'm sending the data to model, but kind of if I ask for another steps or to register, it could be some churn rate for it. And the question I'm asking is, obviously it's important, but what is the actual probability that someone will come and attack me if I'm no one yet? So what is the like the threshold where to really start looking at this really seriously?
very good question. Yes, threshold. To be honest, initially, if nobody can find you online and you basically have no customers, then there is no real harm you can do in a way. So once you acquire customers and you could actually cause harm, then you will already gain some eyeballs on you. Okay, there is something wrong with it. So it would be practically, if someone is already eyeing on you and sees a problem, it's already too late for you.
Yeah.
You should have been prepared earlier. So best suggestion would be as early as possible. So because it will be a way costlier later on. or
Yeah.
maybe cybersecurity, or there is this anecdote, why do we need in company cybersecurity managers? We do not have incidents, so how do you know? And same with data or all these things, that it's initially better to have those things in place, because it's not really, okay, it might be time consuming, problematic to have it in order, but in the long run, it uh, it balances off all those risks, which
Yeah, obviously, yeah, but you like
Uh,
need to think
there
of
is no
short-
there are no thresholds. There is
Yeah.
no, so it's by mainly by feel, or
Yeah.
okay, how big am I? Okay, I should start worry. I already have some actual clients, and I already am processing this data. So
Yeah, because it's kind of like similar. I remember when the GDPR just came in, and like everybody's like watching, like who will get fined, what to
Yeah.
do, and like nobody knows, and the fines are huge, right?
well, with
And I know some companies that are still are not GDPR
Yeah.
compliant, and they just don't care.
yes, but typically institutions and authorities with similar to GDPR, same would be with AI, is that it's typically consult first and punish
Mhm.
later. So with GDPR, it was okay, we see you have problems. Here, authority is requesting, please fix this.
Mhm.
Initially, we will not fine you, but please fix. We have deadline, so and inform us once it's done. So similarly to AI, you are using AI, that's the problem, but it would depend already, because a lot of rules with AI are already starting in force, for example, regarding transparency, not yet for providers or those who prepare AI systems, because it's still starting beginning of next year. So typically approach is that they consult first and then they find, but it's hard to tell how. It depends how bad your situation is, because
Yeah.
if you are malicious and they can see
No,
it
no,
on
no.
purpose, or maybe, oh, there is a legal loophole we can go through, then, because also what to keep in mind, that law cannot keep up with the actual use. So same with AI Act. Initially, it was already years ago, it was first act, but within the first draft, the scope of term AI, it did not fit already the systems ChatGPT or other systems, which we already think, oh, that's AI. But at that time, so they had to rewrite all the AI Act to include systems such as ChatGPT and etc. So law cannot get ahead of the use. So a lot of times it's ethics and what feels okay, how you should act, if law doesn't state it. So it's also important in that way.
Yeah. Okay. Thank you. Got it. So basically, there is a little bit breathing room, and first they consult and then fine. It would be awesome if Vid would also do that, and it takes. Anyone else?
Yeah, I'm back with the terms and conditions. It's actually 3 lines. And I just want to check with you. So by clicking agree, and each time I interact with this AI agent, I consent to the recording, storage, and sharing of my communications with third-party service providers, as described in the privacy policy. So that's 11 Labs privacy policy. And and then if you do not wish to have your conversations recorded, please refrain from using this service. And then I have a privacy policy in a link. Yeah. So what should I add the outside of so sharing?
Yes, so yes, it would be nice to add that the data will be sent outside of server city European Economic Area, because either you need a specific agreement with the provider, or you can simply, okay, he consents specifically that it's okay that we send data outside of EU, and that should be a bit more protected for you.
Yeah. So where they're sending, because I read their 11 Labs privacy policy, it's United States, Netherlands, and Singapore, as per cloud services for Google Cloud, and then payments US, marketing analytics US, customer support US. So basically, the cloud that would United States, Netherlands, Singapore. So if I just say outside of the EU.
Yeah, EU, European Economic Area.
Mm-hmm.
Yeah.
Thank you.
Okay, there's another question here.
Just a short follow-up question. Should I mention all those details? Why we are concentrating on those so many details? Why? Especially about this. I will use your data to provide you services, and if you want to have the service, agree or disagree, and that's all. Why?
To what agree? To this pool block of you agree to this, you agree to this, you agree, because sometimes there is problem when you bulk all the agrees in one place, so you cannot specifically for the example regarding sending data outside of EU. Uh, there are ways where you can not agree to it because that's part of the service, etc. But if there are no ways to legally send data outside, for example, of EU, etc., then you would need consent. So best way is to have the specific check that they are actually informed that in case of the dispute, they cannot say, oh, we couldn't find anything, or it was not specifically requested or put in front of the user that, okay, uh, and in a way, it's easier to prove for a startup. We inform, okay, these are the risks, and it's not hidden somewhere. It's fulfilling this information purpose because, in a way, yes, we have all this information listed in these privacy policies, terms of condition, but nobody actually looks for it. So in case there are disputes or maybe they did not read and later notice, oh no, they are sending my data, you are already being proactive. You are already informing on all these so-called red flags that the other side already understands initially prior to commencing these services from the company. So you are in a way protecting yourself and also being upfront. So no disputes could arise later if there are such terms hidden somewhere in those terms and conditions. So it's a, yeah.
Yeah, sorry. Let's give a breather for Krišjānis a bit. From my experience, what I see also in the financial sector, and you most probably everyone here have agreed to the bank user terms and conditions. So in Revolut or either in Swedbank, and have you seen how detailed they are? But the idea is what we see now in the industry is that it's very important to simplify, and why we need to simplify to ensure that the average customer, average person understands that. And also in terms of GDPR, you will need to prove that it was understandable for the average user that he understands that his data or her data will be sent somewhere outside and what are the legal consequences therefore. And in the end, you will be the one who needs to prove that.
Question. How about this? So can you hear me? Hello. How about safe harbors between European Union and some other countries? I think Japan has one, and how does it make our life easier?
You mean in regard to data protection?
Yes, yes.
So basically, there is this, for example, GDPR. It's applicable to EU countries, etc. But also there are other countries who also want to provide services to EU, etc. And they want to have their system or their internal GDPR processes as a country to be on a higher level. That's why European Commission has these adequacy decisions, for example, with Japan, New Zealand, South Korea, etc., where these countries provide sufficient guarantees similar to those in EU and European countries. Thus it's okay to send data to these countries. For example, it's debatable, maybe you know, maybe you don't, there were problems with sending data to USA. Currently, because once you send from EU to servers to USA, there are taps within the systems that agencies internally, state agencies can see and follow all this data. And also they do not have in US these guarantees to sending that you have all these rights protected in case your data goes there. So for US, there were safe harbors before, there were these data agreements, but now it's a bit hot topic with all the political stuff there. Is it still okay to send data to US? Would it be later on similar as sending data to Russia or some other countries from data perspective? So they work as basically places where it's okay to send data, and they provide similar.
But does it make something easier for us as startups?
Not really. It's same requirements. It's that uh, it provides similar protections as in EU, and it's not. You might have problems if it's outside or it's not a safe place to protect data. Then you would have agreements in place. You would have to have all these bases that you could send it somewhere outside where there is it's unsafe to process.
Okay,
that data.
thank you. Next question. So in the policy, privacy policy, do you have to specify exactly to what companies we will share this information? Like if I use some kind of Microsoft CRM system or Salesforce.com, do I have to say that I'm going to put their data into CRM, which is hosted in?
Basically, that's information about your processors. So in that case, you are collecting data as a controller. You are determining the purposes. So we are gathering this client data, etc. And you are um, uh, getting some companies to do some these activities on your behalf for you. For example, data storage or Microsoft Cloud, etc. And since it's user data which is processed using these processors, for example, Microsoft, you will need to explain it in privacy policy. Okay, we are processing, for example, your data and we are storing it in on Microsoft servers. It does not necessarily mean that you have to mention specific country where it's stored.
But company.
But company should be mentioned. Typically, it should. There are policies which do not contain that information, but data subjects must have rights to know that you are using these processors. Because in case there is a data incident, it might not be your fault, but you might have processor who has this incident, and maybe data leak there. So they could check, okay, you are using this processor, so I am also at risk. Because you are using such processor, etc. So best practices would be to actually list those processors.
But maybe from cybersecurity point of view, it's actually not good that I'm describing like what companies, what services I use, because a hacker can come in and see, okay, that's where you keep all the customer data. That's how you.
Well, it won't help hackers that you keep your data in Microsoft. So in a way, there is information which could be used. For example, for websites, it was typical to check where website, for example, WordPress, since it's sometimes really easy to hack websites in WordPress. People have hidden that information that it's developed through there, but if it's related to data processing, it should be in the interests of the subject. Or if you do not list the certain processors, you could at least list, if you want to see the list of our processors, you can individually request us this list. So it's not available online, but if data subject actually wants and needs it, you could provide it on separate request. If it's really a problem from cybersecurity, etc., that you do not want to list those processors. But since that involves also your client's data, it's important for them, you should list them. It's just if you do not want to publish it, you still must have some mechanism how you prove that or list those processors.
Okay. One more question, if I may. So, what's the escalation path for these data issues? If somebody finds that, hopefully not, but that I'm doing something wrong, does I go to police or it's a data inspection? Some inspector come to my office?
Depending, it could be both. Depending on what you do with the data. So initial data subject, no matter what, he has the right to go to authority. No matter what you say, if you respond, do not respond. Either way, if they think that their rights might be in a way abused or something is wrong, they do not need to go first to you. They do not need to. They can go straight to police. Well, police debatably they would still need proof, but to data state inspectorate, yes, they can, with any reason whatsoever, they can go there and tell you are doing something wrong. And in practice, it's a lot typical, a lot of situations like that, that there is a debate with some person, customer, he doesn't like something, he doesn't go to the company, but they go directly to the state inspector, and then inspectorate goes to you, and you have to deal with all these problems with them. So that's also something to keep in mind, that if there is a problem, you might necessarily not know about it first, but data state inspectorate will know it, and then you will know it shortly also.
Since we have insurance and finance representatives, we had a question. We have a workshop yesterday, and it was told that shareholders of a company can sue the board, which in Latvia is the executive power, and for startups typically consists of co-founders in case something goes wrong in their view. And then the general recommendation was to get insured as co-founders when there are other shareholders involved, and then in the company. And then what would be the point of time when it's actually needed in practically in your view? Is it when you receive first VC investment, or when?
Thank you for the question. Well, I would say it's very untypical for startup share management board to get the DNO called the directors and officers insurance. This is very common for regulated institutions as banks and other really large entities and even state state companies, not the small startups. But of course, if you want to get this insurance, then obviously this should be done. I would say rather after the venture capital investments, when you have a scale, because these insurance are quite expensive. For example, for the banks executives and supervisory board members, the cost would be around 50,000 euros. So, and it's not the largest one. And to be honest, none of the local insurance companies provide TNO. So it means that you will deal with London insurance companies most probably, and it's super expensive. So to be honest, I'm really surprised about this suggestion. But well, maybe there will be some insurtech who will provide this for startups as well.
So legally, you can be sued in Latvia, but in practice, we should not.
No, you can be sued if you are doing really something wrong, like breach of law, negligence, and etc. But if you are like a proper manager, prudent proper manager, you cannot be actually sued about the failure of your business. You can be sued about from the state revenue service if you avoid paying taxes, obviously, as you as an individual. But if you are simply your business has failed due to, I don't know, geopolitical situation or market conditions or stocks going down or whatever, I really doubt that that claim could be like awarded through the court. So don't be afraid of that. Don't be afraid trying and being sued. If you are really a prudent manager, and if you are like listening to Krišjāns about data protection and Lūcija about IP protection, and that's the main message. But the DNO insurance, I don't think this is the market practice here.
Yeah. Yeah, we heard it for first time, so wanted to ask. And then another question: what are so the direct consequences of venture capital investment is that almost always you give some shares from a company, no?
No, I would disagree really. What I see now in at least Latvia and Baltics, that in the pre-seed and seed capital, actually venture capital funds, they are providing convertible loans and or even safes. Have you heard about safe? Simple. So this comes from US. This is basically a convertible instrument, bit similar as convertible loan, but in the end, if you don't raise successfully the next round, you are not obliged to repay the loan. In convertible loan, you basically convert the loan in the next round, which is successful, or either you repay it, and this does not delete your share capital. And I think this is well, a very reasonable approach. And then on in later stage in Series A, and maybe sometimes in seed, but basically in Series A, when you have already some business case and you have built like a business which is ongoing, then you can provide equity investments. So, but I think, well, you have a lot of amazing venture capital funds here in this house. You can talk to them directly, like Bad Ideas or Change Ventures, or I don't know, Build It is here as well. I'm not sure, but I would really suggest to talk with them. But from my experience, none of these funds are squeezing out the equity now. And if they are, I would say be aware.
Yeah, thank you. So it's nice to know that there is no equality sign, and venture capital does not imply giving equity. Thank you.
Do we have any more questions here from the hall? Anyone maybe has questions online? Oh yeah, I see. Zana, please, yeah, turn on your mic.
Yeah. Hi, do you hear me?
Yes, we can hear you.
Okay, so I have a question. We as a startup have domain bought and registered on private person's name, but we don't have a company registered. How would you suggest to set up all the privacy policies? Who shall be the data collector in this situation?
So yeah, yeah, probably like when your company is starting to operate, it's good idea to transfer the ownership of domain to the company, because yeah.
Oh, so I forgot to mention. So it would be to start to collect emails from people who would like to receive newsletters and so on. So they should check the box that they have read privacy policy and terms and conditions, and who shall be the. Do we really need to start a registered company right now to collect emails?
Yeah, just an introduction, intro with all this situation. So what I see from startups, so you are sometimes, not you, but startups in general, startups, you mix a bit up what belongs to whom, and what should be owned by the company and what is owned by you as an individual. So I would suggest to sort this out, that the domain name is owned by the company, IP is owned by the company, and the company is that is processing data. And then we can talk about how the data is processed.
Yes, but as far as I understand, you do not have company yet. So what?
No, no.
Not yet. So regarding privacy policy, so there is a requirement, as you might know, that you must input information about the controller who holds the data. But typically, it's the company name, company email, etc. So if there is no company name, then in privacy policy, it could be individual, unfortunately. So as there is no yet company, there must be some certain person or someone who is responsible. Thus, all this information could be to this natural person. Although you should not maybe name, surname, and give your home address in your privacy policy. But email, number, etc., should be listed there. In regards to domain name, etc., since you do not have a company and there is all this is registered under a person, it depends. If you are that person and you are currently holder of this IP, then okay, you can just keep it, and once company is established, you can just rewrite it onto the as part of a company's property. Up until then, it's a bit more problematic. Maybe if you do not have company between all the, you probably have co-workers or co-creators of this startup, maybe agreement between, not sure how in practice, that they are okay or you are okay to split this domain, for example, across these members, even though it's in your name, maybe some sort of that agreement that, okay, we do not have a registered domain, do not have a registered um, some other property, maybe agreement between the parties. Okay, currently while the company is not established, owner is that, but once we establish it, the property rights go to the company, etc. Maybe something in a written form. So in case there is later on a dispute, then there is this agreement. Okay, but maybe some other thoughts. That's the idea, because generally idea is that you have company and everything is there, but always if you do not have it, always agree with people around you, have it written, have it on paper, and have it clear that everyone understands that, okay, for example, domain holder is one, but we are ready that once company is established, we are registering. So yes, that's general gist of it.
Okay, thank you.
Any more questions? I see Martin, you have a question. Yeah, please go ahead.
Yes, hi. I have a very practical question. Let's say a new startup arrives at your office and says, "Hi, we need help with the setting up these GDPR policies." What are, like, from your experience, very step-by-step approach, how you approach this solution?
To fix your privacy policy and website documentation. So,
yes.
Well, in practice, it's typically at first a call to understand what you are actually doing. So previously in the data presentation, it's understanding or so-called mapping your data processing activities, what you do, what are your services, where are you, what kind of data you need for those services, where do you send that data, who also has access to data. So there are these questions in our head where we need answers to, and typically we ask companies, and companies can self-assess these questions. I think previous presentation regarding data will be available somewhere to the Startup House members probably. So there is also this checklist. So where are data sent? And basically those questions answer the requirements what privacy policy must contain. So it's going through that, and there is no like one way to do it. It depends on company. Maybe for some companies you already know what they generally do, what data process, then questions are not as targeted. But if you have some innovative technologies, you use AI then or something, then you must assess a bit more in depth. But yes, typically it's by questioning, preparing this questionnaire and making a draft based on these answers, and then reviewing again communication with companies, understanding their needs and finding solutions for those needs.
Krišjānis forgot one very important first step is onboard the client is what we do and agree on the budget, and of course for the startups we have a better price proposals than rather than like large corporates. And I don't know whether colleagues mentioned already, but we have also currently shared mission program opened for defense sector, including cybersecurity. And this is €100,000 worth of advice in legal and tax consulting. And this would even include drafting all the privacy policies. So if you know any defense, I see the sweater with defense hackathon. I'm targeting you specifically. So if you see any good defense tech company or cybersecurity focused company, then go ahead, apply.
Yes, and scope is not only defense, it's a bit wider. It's public readiness, awareness in case or acting in case of crisis. So it's not only defense, military, but it's also this or shared mission project is also a bit for wider range of companies. So if you see if you could fit that image, yes, on our website there is shared mission and you can check out more.
Oh yeah, great, Alice.
Hello. Do you think we could just generate all this documentation with AI, like the privacy policy, cookie thing, and like the founders agreement thing?
Yes, you can do everything with AI, but it will most likely not be that good. Well, the problem is it will be later on. There are because a lot of these documents, a lot of these policies, they are not really generic, but it's not like they are really different for different companies since EU law and GDPR is applicable to all EU countries. So mostly all EU countries must abide by these policy rules, etc. So yes, it could be generated by AI, but you still need to uh, check it, you must rewrite it, you must personalize it, and in the end, there still should be someone who is competent in the field who could review them. Because neither do you nor AI doesn't know what's missing there, or AI doesn't see problems we do yet. Maybe years ahead, yes, they will be much better, but currently you could prepare drafts, you could see maybe competitor websites since their data processing activities or use of AI could be quite similar. So if you check 5 to 10 similar companies, by mixing up all this information, you can kind of understand how you would do it and how your policies or documents would look like. So you can, it's easier, you can use AI or tools for initial draft, but as I mentioned, a lot of privacy and other documents are informative. So AI would not know how your company exactly works. Only you would, if you feed it, yes, if you can actually feed all that information, but also add your own input, explain. A lot of documents are just informative. They are not as much, as I mentioned in the previous presentation, privacy policy is worst document for a lawyer to draft because nobody actually reads that document. So if you explain in your own words and policies what we do, it would be sufficient because that's the goal. So for you as a company to inform users, and you would also appreciate as a user that, okay, everything is in clear and concise way explained to us. There is no need for legal lingo, etc. And a lot of great policies are done without it. Ramon mentioned it. So you can do it on your own, but don't take it as granted or as a good way because someone should reread it because AI does not know how it should go or what would be the correct way. And sometimes human oversight is mentioned in AI. Human oversight would be needed.
Well, my general saying here is that whether AI will replace lawyers, no, but the lawyers who use AI will replace lawyers. And what I see now, working actually a lot with crypto service providers, now this is very a hot topic in financial sector, and there are a lot of people who are drafting their all the policies for the licensing for submission using AI, and you can see it like really all immediately. And obviously, the regulator and everybody will see it. So, and then we understand that basically these guys don't understand. Sorry for the word in French. So basically, you need to have your input as well, because everybody will immediately see that it has been generated by AI, and basically this company does not understand, and most probably this is only a facade, and you are not actually following this procedure.
Everything. In the beginning, I could do everything with AI because nobody would care. And when I would have a lot of money coming in, I could just pay someone to do all that.
Yeah, you can do that as well. Of course, and I would say initial stage as a startup, you need to think a lot where you put your money in, and definitely sometimes these things as a legal like privacies and IP protection is somewhere in the very big last place in your list, but when the real venture capital come in, they will employ us, and then we will review, and then we will say this is the problem, that, and then they will start talking about the valuation, and the process will be lengthy, and you will have a lot of obligations and reps and warranties and stuff. So my suggestion is, and especially for IP protection, don't forget about it, because in my experience have seen a lot of startup founder disputes about IP protection, and this is very costly, and basically it can like sink your startup.
So when these investors are coming and they employ you to check our company, wouldn't it be that you would check and then tell us what's wrong, and then we could fix it and then just like move on with it? Or it would be like the investors would see, oh, these guys didn't really think about these things, so we're not going to trust them.
That's one. Yeah, so it depends. I have seen the venture capital pulling out its decision to invest in the actually one of the now most famous startup company, but because they have seen a lot of risks and they do not trust the founders. Of course, but in main situations, in larger part of all those investments, actually, we after due diligence, we identify the problems, and then the company is paying us to rectify these problems. So, so this could be done if you can do it. But as for these IP questions, sometimes the coder is not anymore around, and you cannot like agree with him about the transfer of his IP or hers IP rights. So it creates a lot of problems. And I know that venture capital funds, they will look at IP as the first thing in the company, especially coder rights.
Yeah, I can say from my experience as well that so if there is one thing you should do to protect you, then that is IP, and those are agreements with everyone who creates your IP, that that IP belongs to the company. That if there's one thing you should do, that you definitely should do.
And therefore you need this company established. And I know that it creates a lot of burden. You need to have accounting and etc. And then the state revenue service comes in. But otherwise, you won't be able to arrange all your IP rights in a proper way.
But in the founders agreement, you can also mention that everyone creating the company, everything that you work for and create belongs to the company that will be established later. That can also be the case. At least you know better. That's my experience.
No, none of the venture capital funds will invest in private individuals. So you
Of
need
course.
to have these companies in place,
Of course.
and then if there is even some income already coming in, like some subscription fees and everything, so you need to have the company in place. And why you need also the company in place and shareholders agreement is to agree with all the founders of your participation of I don't know, a share structure, obligations. Actually, non-competition is very essential, because otherwise, if you don't have that kind of agreement, and the one of the founders can go and set up the same similar company and take away all your idea and commercialize somewhere else.
We have a hand from Martin for a while, and then afterwards, yeah, see you. Yeah, Martin, please turn on the mic. Yeah.
Yeah, thank you. Follow-up question. For example, if we are like a startup who is starting our operations and we need all this legal help, assuming we don't take any like help from AI or we don't take any like pre-made templates, we need help of the law office to have all these documents in place. So it's like the shareholder agreement, intellectual property protection, GDPR, everything. How much we should budget for your services? And just a note, we are not in this defense category.
Well, first, my suggestion would be please use the templates that are available as starting Latvian Startup Association webpage. Have you seen those? And these are quite good ones and actually developed by our firm. But as for the company establishment, it depends if there is how many founders and management board members, but it's around 1,050 euros or something. It's not a very expensive thing. Shareholder agreement, it depends. So, well, we can provide the offer later on. So we need to understand exactly what would be the structure of the company, how many founders, and yeah, what should be included in the shareholders agreement. But in order to cut those costs, as I said, please use those templates. They are pretty good, and they will initiate your thinking about. You will read the shareholder agreement, and you will start understand. Hey, what is drag along or tag along or whatever? Yeah. So these are like these things you need to understand when setting up actually the company. Hope we answered, but I would say to give you exact budget, we need to understand more the business, the startup, and the founder structure.
Thank you. I have one more question. It is if I come in a startup with my IP, like a code base or some code I have developed in other projects, but which is belonging to me.
You can invest it in the company, you can evaluate it, and you can put it in the company as the sort of investment. You can pay with it as for the shares. You don't need your own money, and you can become a founder in the company. It's possible. So one small detail: you need to have the valuation of these IP rights.
But the valuation, it can also be agreed upon between the founders or the shareholders of the company, right? Or
for the commercial register to pay for the shares with something else which is not money, you need a valuation made by certified valuator, which is in the register of commercial registers. But it can be easily done. I know that some even law firms do that.
But if I'm let's say there is this case, I am a coder, I have built some working code prototype, and I'm joining the team, and we agree that because I'm coming in with this code, I get 20% of the company, and then the code belongs to them. Do I need to still evaluate it to do that, or can it be like an agreement with the shareholder, with the team?
I would say there are two ways how you can do it. One way is simply by establishing company, you get those 20%, but you need to pay something like a nominal value for this company, and the minimum when the company has more than one founder is 2,800 euros. So basically, you will need to pay this nominal value of this 20%, and then you can transfer the IP rights to this code through agreement and agree that it is sort of your investment or whatever. But if you want to invest these IP rights and without paying anything, then you need to have this valuation of the outside valuator. You heard it? Yeah? Okay. All right, good. All right, do we have any more questions online or from the audience here? Or we've run out of questions? Oh, there is Walters. Yeah, Walters, go ahead.
Yes, I wanted to ask regarding trademark registration. So, what would be your like practical suggestions from practice, like for a new startup? How would where to start and like step by step? Should I go like to each country separately, or only in the countries where I plan to work and like that kind of stuff, like from experience?
Yes, unfortunately, I don't know like the costs of registering trademark because we have other colleagues who work with trademark registration. Uh, so essentially, like the first thing we do when we think of registering a trademark, you have to check what trademarks exist and whether there are something similar to yours, and that would be the first step. You can like try to do it yourself, but this is also a service of a legal advisor. But because the first step to checking is because it saves money. Namely, this trademark search is cheaper than actually submitting application, because submitting application of registration is also subject to state fee, and these fees are quite high. I mean, it depends on the jurisdictions you want to register your trademark. So the trademark search would be the first step, and after, yes, you have to think of jurisdictions. So we have in EU this EU trademark when you can register it in the whole EU, but it is all the it's all about the cost. And so you have to do so basically, because it costs money, you have to do it in a targeted way. You have to, like, namely, you have to think where you want to operate, like your business activities, and then based on that you target the jurisdictions. But unfortunately, I don't know like by heart the state fees for and how much it costs to register like EU trademark, or how much costs the national trademark. If I'm not mistaken, I think, yeah, I mean it really depends on the how the they have those um, service classes, and it all depends on all those small details. But if I'm not mistaken, like EU trademark registration could be around 1,000, like the fee, the service fee for the patent office. And that's why you have to do the search, because it would be very disappointing to pay this high state fee and then later found out that there is very similar trademark. So that is what I can share from my side, because on a daily basis, I don't work with trademark registration. I don't know, Krišjānis, have you had any experience with trademarks on your side?
My other colleague, who is also Krishan, is called, he mainly registers, but in regards to trademarks, what I wanted to mention that there are these sites online, although you are not legal expert, but within, if you are a startup, you don't have cash for lawyers to check all these trademarks, who can actually assess if they are similar or not. You can on your own EUPO site, and there are similar sites where you just insert your name, your trademark, and they will list out all the, based on these words, similar trademarks. So even though you might not maybe differentiate, oh, there is one letter is different, it's fine, we can register. It's still not that simple, but you can at least check if there is directly the same name registered somewhere. So it's not necessarily that at this initial stage you need a lawyer, but you can also check. You can just trademark EU trademark databases in Google, they will probably show these databases, and you can check them for free. So you could at least check if it's identical or something like that. So later on, you can say, okay, maybe let's change. Maybe this trademark would not be registered, but also it's not like guaranteed, since there might be trademark in use which is not registered, but the business provides those services already. So there might be trademarks used in practice, although not protected, but also some additional search might be needed. But so to sum up, you can also check on yourselves, but there is no guarantee that you could actually tell if it's different or similar, but at least give you a thought, oh, maybe there is a risk here, maybe we should consult a lawyer here or something like that. Yeah.
Yes, and if you have like practical questions about costs and like what documents are needed and things like that, like then in Latvia you can contact the patent office, and they have like they register trademarks, so they can maybe also help you with some practical information.
From practical perspective, what I see from the startups and actually from all other companies, so they identify the services where they need to use this trademark, and then they identify the main markets, and they never register like for whole Europe or across the world. Even it would be impossible. So they really focus on those main really markets, and that's how you manage your IP.
All right, thank you. I see.
Just a follow-up. Did I understand right that if I choose this option to register this trademark in EU, so it is valid in all the countries in EU, and I don't have to go separately to each country and register there also?
Yes, there is this one-stop approach. Basically, you apply with one application, you submit it to Latvian Patent Office, and they arrange it. Like they take care of it. So from a side, it looks like it's like one jurisdiction. Like basically, you apply one application, but in essence, just the patent office will do the work. So yeah, you can do it, but in real life, still in terms of jurisdictions, it will be all those countries. The trademark is like valid or registered. I don't know if I said it out in a clear way, but it can be done with one application at one stop.
Okay, thank you.
I see from the comments on Zoom that Ilva is writing EU trademark is 850 euros, but there is some kind of discount to small medium enterprises, and it might cost only 212.5 euros. So yeah, 850 is what I remember as well from EU trademark registration. So it's been like that for years. The US was a bit more expensive. It took a bit more than 1,000 to register the trademark in US. And yeah, then there's a question, what about the rest of the world? There are other different regions that you can register for. For what we had that time as recommendation is not to bother with Asia, because you can't fight anything anyways there. So if you register in EU and US, then that should be enough kind of for most of the world that works with the same legal practices as we do in our region. Or do you have any other suggestions regarding that?
I mean, I think it is wise to register where it's relevant to you, because in essence it ends like if you don't use your trademark in the jurisdiction, it doesn't matter if it's registered or not, because like the most important thing after registration is actually to also use your trademark. So it is pointless to register something all around the world just because at the end it all ends with jurisdictions where you actually are active and actually use your trademark or other rights as well.
Yeah, and don't forget about LATAM. You need to register, and I think it's protected there. I have seen a lot of startups, successful ones, they register their trademarks there as well, and Middle East. So of course about China we know, don't register patent there if you don't want to like copy it, and then that's it. Yeah.
I had one friend of mine who had a company. They had a case that they registered their trademark in the Latvian patent valde. They didn't register for EU, but for Latvia. That's less expensive, and they thought so. They're protecting. They're mostly operating in Latvia. And what happened with them is that they got a company from Italy, if I remember correctly, who registered the same name. I'm not sure about the graphical sign, but the same name in Italy and maybe in EU. And then they said that this my friend's company are breaching the law and they cannot use that trademark anymore, even though they had like registered the trademark much earlier, and they had the domain name and like publications years before the other one. So my learning from that was that there's no use to register anything in Latvia only. It should be already like EU first, because if we ever think about going outside of Latvian market, then there's no protection. And even if I don't go outside of Latin market, if someone registers the same trademark in EU, then it can override my rights on the brand. What are your comments on this?
Yeah, I think generally, if, like the situation is quite possible that there are two similar trademarks in different jurisdictions, but at the end, even if they got the EU trademark, I mean, I'm not sure. Like, I feel something is missing because generally, like, if you have a right, if you got the right first, then no one can take it away from you, even they registered it somewhere else. And also, I'm not like, I mean, companies write all kind of cease and desist letters, and they include criminal code and all kind of crazy things. But it does. I mean, if they like it just sounds like they wrote all the things they wanted to say to this Latvian startup because, I mean, the Latvian startup has like the valid rights to trademark in Latvia. And also, I'm not sure how it is possible because in order to register a trademark in EU, like Latvia is in EU, like they do trademark search also. I mean, a bit for national levels as well because like Latvian jurisdiction is part of EU trademark jurisdiction, so you have to check it, and it can affect. So I believe they can register trademark for Italy while they are the same exact in Latvia, but national trademarks, like it's not guaranteed, but they do affect registration of EU trademarks as well. Like, I mean, probably each situation is like must be assessed differently, but there could be a conflict, especially if it's like copy paste, like the same. So yeah, but for trademarks, there is this principle: if you were the first, then no one can take it away from you. Even for patents, like someone patents something, but you invented it, like for sure, like you didn't copy it, and you use your invention, even though you did not patent, you are not the one who patented, like got the patent. These rights still cannot be taken away. Like so, yeah.
I also had that same situation, actually quite similar, for of our clients in my previous firm, and definitely there are ways to fight it. And as Lūcija said, it doesn't work that way. That Latvian trademark will simply be discarded due to the EU trademark, and you should check who was the first one who used that actually, and yeah, there should be some nuance.
Yes, and IP culture, I think maybe add on that in different countries it's a bit different because there are companies who pay certain people to always check if there is some IP or similar IP who are trying to get into the market or might use it. So they could be also quite litigious in that regard. And in addition, what I've heard from situation, there are also, well, why I agree that yes, it doesn't make sense that there is trademark registered in Latvia, which is part of EU, and then someone else says no, that's not okay. Even though, but there could be also some situations, as we all say, it depends that there could be situation that those both trademarks were not registered at one point. EU or this Italy company used it already years prior, already they are years, but although not registered, then there's this Latvian company who after they start using similar, after the Italian company already uses and provides services for years, including Latvian company registers it first, and then they register, so there could be a conflict who used it first and where, and maybe I could see that, but yes, it's not a standard situation, so it always it depends.
It always depends. That is true. All right. Do we have any more questions? Oh, yes, has question. There you go.
Thank you. In one of the previous answers, Ramona mentioned registering €1 enterprise. If with one, you said if there is one founder, there is no need for 2,800 capital. Um, it sounds attractive, and if are there any caveats? So maybe from how it's viewed by venture capital, or in the end, it still boils down to SIA. It's just the difference is in the starting capital only.
It's also SIA. It is called small capital SIA, but basically it is like limited liability company. And as for the venture capital funds, they will ask you to increase to the normal capital, because even they, for example, provide you a convertible loan or safe. Their initial idea is to convert and to become a shareholder, and then you will need to have this capital increased. Of course, maybe there will be some exceptions, but normally, yeah, usually they ask. But if you see that you will be the sole shareholder and sole management board member for some time, maybe it's okay for them until the conversion, that you keep this small capital, a limited liability company, and then when they convert, you need to increase the share capital up to this minimum according to the commercial law. Yeah.
And you just mentioned that in the long run, their interest is to become shareholders. So
Definitely. No, none of
we
the.
return to the previous question. Then even with a convertible loan, it's not giving equity immediately. It's like giving
When you get
equity
the
with
next
a
round.
delay.
So the idea of convertible loan and of SAFE is that they are giving you money to start running successfully your company, and then they will be the first like pre-seed or seed investors, and then comes the other investors like in Series A, and they will give you more money, and then these pre-seed and seed investors will convert, and their conversion sort of, they will get more of the shares than those next round investors. So they will be their investment will be valued higher, because they were the those who risked more in this initial stage. But normally, the idea of the venture capital is to be in the shareholding, and then initially to exit or go to the IPO or whatever. But this is only when the company becomes more solid. There is like a market potential there, when the startup becomes a scale up.
Yes, and so there are no common scenarios when you receive a financial loan and when you return it, convert it in a purely financial terms as a profit that from a few.
Well, none of venture capital funds would agree, because obviously they are not a bank who is simply lending you. And even if you see, look at the interest rate they are like putting in the convertible loan agreement, it's ridiculous basically. So their main goal is to convert. So don't look at it as the loan. Look at it as the instrument that will be converted. And even in the convertible loan agreement, it is written that you cannot prepay the loan without the consent of the investor. Yeah.
Convert means convert to shares.
I did not know this part, so I thought conversion it's just return with a delay in the next round.
No, yeah, convertible loan means that it is a loan that will be converted to shares at some point. Just the point is delayed. That's the.
And are there any consequences? So the straightforward consequences of except for co-founders being the only shareholders when there are other shareholders like venture capital funds. Uh, so it seems the direct consequences is that they have shares that do not give them voting rights typically, but they give them a priority when getting dividends.
No, they will get voting rights. Yeah,
Voting.
the ones who are not getting voting rights are usually employees. If you have employee share options in the company, but the venture capital funds, they will most probably be a minority because founders usually are majority, but they will have veto rights. Did you have a presentation about shareholders agreement and about veto rights or something?
We have with shareholders, but without veto right.
Interesting. So I would really suggest you to read a sample shareholder agreement, which is available in Start in webpage. So you will grasp the idea how these relations are organized, because the venture capital funds also in the convertible loan agreements they list the material issues in the company that you need to pre-agree with them. You need to get the pre-approval. For example, like increasing share capital or taking large loans and changing the business of the company. So the venture capital, as you know, they are investing and they are providing their knowledge, connections, etc. But they are also trying somehow to control and guide you. This is their investment. They need to protect it.
Yes. So this was the context, and the main question was: there are those direct consequences that are very transparent because of them having a certain type of shares. What we learned yesterday is that there are some practical indirect consequences. One of the only one which we are aware of is that in Latvia, when you're registering a company, you have to list all the patijas labumu guvējs.
Ultimate beneficial owners.
Yes.
25% and more.
Yeah, and then this might scare some venture capital funds away because they, that's what we heard yesterday, that they do not want their internal structure to be publicly available as it is required in Latvia. So it's becomes a burden for registering company in Latvia after it was registered somewhere else. Are there any indirect or not so straightforward consequences of venture capital becoming a shareholder in your company that we should be aware of?
Guys, I think I needed to be in this presentation and challenge it a bit because, I have been working with like 10 and more venture capital funds, and I have never heard from them that this is the problem. And at least, for example, if it's Altum-backed venture capital funds, then they will not register any UBOs because they are basically owned by the state. Like now, new bad ideas, Build It and Outlast has it. And even if they have, they usually are not going about 20-ish%. And then you don't need to disclose any UBOs. So I think it's some really strange comment. And as for the consequences, basically, of course, these are the veto rights. You will have those veto rights from them. Even they are minority, according to the commercial law, they would not get those rights. Statutory rights, but as according to the shareholders agreement, they will ask and they will get it. And if you want to see what are those rights, like some examples, just read this sample shareholder agreement on the starting webpage.
So all practical consequences are mostly written down in the agreement that they propose when they offer to invest in your company, and there are no side effects.
Definitely, even in convertible loan agreement, you usually attach addendum where you list those veto rights that you will ask, or some other principal provisions from the shareholder agreement that the fund will ask. But in practice, basically, the next rounds comes in, new investors come in, and you basically renegotiate everything. And maybe this initial investor needs to step down from some of his or her requirements because he sees the potential of the new investor coming in with like a larger investment. And then they, of course, if they are reasonable investors, they will agree to some compromise. There are some examples, I know from my experience as well, that there are unreasonable investors, but you know, the reputation goes all around the market and everybody will know that. So
it's a trilateral agreement and negotiation in the next round.
definitely, the shareholder agreement is between all investors, all founders, and the company. So it's multilateral. Everyone is involved. Everyone can fight their case. And I really encourage also startups to engage lawyers. And recently, for example, I had experience representing startup against some couple of funds, and it was very interesting to challenge those funds and to get something better for the startup. So normally, of course, to be honest, what I see that law firms represent the venture capital firms, and the startups just simply go with the flow. But I really encourage sometimes to use as well, because you will fight your rights. So it's quite important.
Thank you.
And one more important thing, what else the venture capital funds gets, and also angel investors, sometimes they ask for a seat in the management board, but this is not also common in the seed or pre-seed. This is common on next rounds, and they sometimes ask for a board observer, but without any voting rights.
I can say that sometimes the investor can be a good player in the board if you run into some conflicts among the founders, then the investor can be like a good mediator or support the discussions. I wanted to comment something. Yeah, we had the founders agreement that we talked about. It was not shareholders agreement, so we didn't talk about veto rights there. But you should look at the shareholders agreement on Startin site. As Ramon suggested, there will be all the information about veto rights.
And we have like this very good idea some time in some particular time period to organize maybe some workshop about convertible loan agreements, because that's what I have heard from a lot of startups, that we need to walk through everyone how to what is like cap floor valuation, cap valuation floor, and all those weird things you will see in the agreement. So yeah, we will do that, but I don't know when.
Okay, we have just 5 minutes left. Is there like any one last question, either online or here? Or then we can wrap up? Yeah?
I just, while Ramon was talking, I remembered, like I heard what I said, so I wanted to make self-correction about trademark registration. So if you want to register like your EU trademark, you have it is done through EU Intellectual Property Office, not the Latvian Patent Office. So that is a EUIPO, yes. So yes, and so yeah, but Latvian Patent Office can help with international patent registration. This is why I probably mistaken it. So yeah, sorry.
Yeah, thank you. And the registration in EU IPO is like it's online. So yeah, you can do it easily online. Quite easy to do that there. EU IP No, it is called EU IPO, International no, IPO. EU Yeah, EU IPO. It's a European Union Intellectual Property Organization. That's the no, that's a yeah, that's a little bit different. That's a little bit more complicated. Just a little bit more complicated. Okay, should we do a group photo? All of us together on the stage? Yeah, okay. Let's go. Group photo. And those online, you can turn on your cameras so we can have you in the yes. A lot of questions, right? Yeah. I'll take away the water so we don't break something. Yeah, I think we could move the table a little bit so we can stand on the back. Oh, yeah. Šodien, es paņemšu to miķīti. Yes. All right. Yeah. So yeah, join us, please. Yeah. Oh, okay. So if Toms, Walters, Mārtiņš, Kristīna, if you can turn on your cameras, we'd love that. Guna, Gita, Valeria, Marina, Ilva, Dainis, Diana, Ilza. Yeah, please. Yeah, now our partners can also see you, that you are real people there. Awesome. No, wait, we can ask someone, no? Uh, Thank you everyone online for switching on the cams. Have a great rest of Friday.